So we just kind of wanted to introduce what we are going to talk about today is a little bit of safety and the department safety model. Yesterday, after we conferenced, we met to kind of discuss some of the feedback that we'd had and some of the takeaway from yesterday, and just briefly kind of discuss some of that. As we saw from our data and the data discussion yesterday, it does seem that we have some encouraging numbers in that our trend is headed down as far as removals go. And that's pretty much across the board in all of our regions, which is good. But of course, we continue to have concerns about our removal rates in basically all of our regions, as they are, 2 to 3 times that of the national average. And our processing times for cases, how long it takes to resolve them, of course, has been identified in the audit by the feds as not meeting the goals, and the department has developed a performance improvement plan to address those delays, which we're hoping through education and through participation with all of our stakeholders of attorneys and judges and CASA workers and GALs, that we can do better work and we can address these issues that have been flagged as concerns for our child dependency work here. We do have some courts over time that have tried some new things. So we do know that it is quite possible with a little effort to really improve those numbers. And so that's really a goal of getting your teams together at this conference and hopefully developing a more collaborative system that allows you to work as teams and look at these, data points to help inform decision making. We seem to know that we need to do better work because our survey yesterday pretty unanimously identified safety and reunification as being the primary goal of our system, but yet the vast majority of us thought that we were just meeting that goal some of the time. And so I think there is a recognition that we can all do quite a bit better work, and the more educated we are and the more informed we are and the more we hold each other accountable to do that, the better our system is ultimately going to be. Today we are going to focus on safety, and when I say safety, not drug or alcohol use, not compliance, not merely the possibility that something could happen in the future, but safety itself being the driving force for decision making. And I'm going to turn it over here to Marty Vining to give you a little background on the department's safety model. They have adopted a particular safety model, and safety is defined in that model. To talk a little bit about what Deb said earlier, is that it depends on how you define safety. And so at least we're going to try to educate everyone on maybe the common terminology and a consistent definition of what at least the department's model is, and the model they've adopted and committed to following, and which they would like us to help them hold them accountable to meet this model. So Marty, I'll turn it over to you.
Thank you, Justice. I'm going to leave the actual nuts and bolts of our safety model to Ike Jessee, who will be presenting that core training to you this morning. But I want to make a few general statements about safety. I guess the first thing I want to point out and talk a little bit about is how safety assessments really do start within our communities. It is our communities, it's our mandatory reporters and our constituents that live within our communities that really do start safety assessments. They're the people that recognize that child abuse is occurring, and they reach out and call our centralized intake hotline. So that being said, I guess the point I want to make regarding that is how important it is that we keep that in mind as we're trying to improve child welfare in Montana. How are we educating our communities around child abuse and neglect? And I know that that currently looks really different from community to community, but I think it's an important thing to keep in the forefront of our minds as we move forward with really trying to improve child welfare. How do we bring our communities along with us? How are we educating our individual communities about our child welfare system? And so I guess I throw that out there to all of you with the intent of hoping that there's ideas, that you guys can come up with ideas and bring them forth as leaders, because as I think Justice stated yesterday, we've identified you all as leaders within our child welfare system. So that is one area where I guess I'm reaching out and asking for ideas and support from all of you of how we can do that. Once somebody, a mandatory reporter or a community member, decides to make that call into centralized intake, that really starts CFSD's process. That call into centralized intake is assessed, and it's categorized, and it's called out to the field. So Nikki Grossberg oversees our centralized intake and has done a lot of work making sure that centralized intake and that intake unit isn't forgotten in improving with how we do those assessments. And we've actually implemented a lot of quality assurance around oversight on entering those reports, making sure that we get that right. As far as the field, really our assessments begin at that first knock on the door, and really should be continuing throughout the life of the case. Safety assessment is not something that should just happen one time and be done. It's something that we should be doing, again, like I just said, throughout the life of the case. And really it does include all of you as our system partners. We should all be assessing for safety throughout our involvement with families. An area of focus that both Nikki and I have had since coming into our roles is really about transparency. The way we do our assessments should not be a secret. We should be transparent in that process. We should be transparent with all of you. We should be transparent with our families. And really, that should continue on, again, throughout the life of the case. Families need to be included in those safety assessments. We need to be having conversations with families about safety that has been identified. They should be a part of their safety planning and the development of safety planning. We have a real focus being put on internally with our staff right now about bringing families along through our process as a partner, not doing things to families or really for families, but with families, bringing them to the table, hearing their voice, talking to them about how they see the situation, and using that information to help guide us moving forward. I'll give you an example of a focus that we're spending a lot of time talking about right now, and that is on treatment plan development. Families should have a voice in their treatment plan development. We should not be developing treatment plans behind closed doors and saying, here's your plan. We should be meeting with them. We should be talking to them. Their voice should be included in those plans. And I say that to all of you because we've been saying that to all of our internal staff. So that is not a secret that we're moving in that direction. And honestly, I hope that all of you hold us accountable to that. That is a question that we should be asking our families continuously throughout the life of a case. Just one really quick example of how we're trying to bring family voice to our system is we have completed a survey with our families. We worked with the University of Montana, and we did develop that. if you're interested, reach out to me. I can get you the exact numbers of how many people responded and what that looks like. But I'll just summarize the results of that survey really quickly. There was good and there was bad information, or information that we can improve on in there. But one of the things that they said is that we can improve on including their voice in our planning. We did ask a question about who they feel supports them through the system, through the legal process. And I think that there's areas that we can all improve on in that. So that being said, I just wanted to kind of give you some information on where we're trying to go internally, and really the vision behind how we should be doing assessments, and the importance of bringing families along through that process. I guess I just want to throw out here that I think if we're all being honest about what safety really means and what it looks like, we would all admit that it probably looks a little different to all of us. I think as system partners, we all bring different values and different experiences to that discussion. And I think like there's going to be times where there's rubs between all of us because we all have a different perspective. But I want to just say that that's why it's so important that we use our safety model to really guide us in our decision making. And that we really have been coaching our staff around that as well, because we know and we recognize that we all bring different ideas of safety. But really focusing on intervention should be based on safety, not on our personal views. I think yesterday Judge Gustafson mentioned that we shouldn't be removing children based on poverty. And absolutely, poverty doesn't make children unsafe. I do have to say that I haven't seen Montana do that. I think that's a positive thing. But I think that there's other areas that we can improve on that. But I think it's important to just lay it out there. We all have different views of safety. So what do we do to move our system forward? We focus on our model. We use our model to guide our decision making. One thing that we've done to really try to move that forward is bringing back our immediate danger assessment. I need to be clear that by bringing back that paper form, we were always assessing for immediate danger, but we felt like bringing back the form would really help solidify and help our staff articulate what immediate danger really is. For me personally, when I spend a lot of time on the phone with families, listening to them, and one of the things that I was consistently hearing was, why did you remove my kids? What, I don't understand. And we really felt like by bringing back that immediate danger form that our staff could articulate the why to families and to all of you as well. And all of that document should be being shared with all of you, and it should be being shared with our families as well. Another piece that we're really working on internally is teaming. How are we bringing along our community stakeholders, service providers into safety decisions? And how important their perspective is when making those decisions throughout the life of a case. Yesterday, family support teams were mentioned. Really, the vision behind creating those teams was to bring our community stakeholders and resources together, along with families' natural supports, to the table while making those safety decisions. Is there a way we can mitigate safety concerns while providing safety planning within those teams? So that really was the vision, to try to prevent removals. And if removals did have to occur, how could we implement plans using our teaming approach to reunify children with their families sooner? MDT teams and CPT teams, how are we looking at utilizing those? The department is really at a stage where we know we need to draw in our community partners. Child welfare is too big for us to bear the load alone, trying to figure this out. We need all of us working together. And I really do think that CPT and MDT teams are a viable resource for ours that we do need to continue to strengthen. So that's another internal area that we're going to be working on. The second question I get from families is, you've removed my kids, and maybe we've done a better job explaining why, but the next question always is, what do I have to do to get them back? And really that answer should be based around our conditions for return. Because again, that question leads for personal interpretation, right? Everybody's idea of what good enough is exists. And how do we start moving towards consistency around that? It's by using our safety model and using our conditions for return. And again, that should be a transparent answer, and it should not be a secret to families or to anyone involved in our cases of what that looks like. And lastly, I guess I'll just talk about our core trainings. The core trainings is a condensed version of our safety model. The vision behind these trainings was developed through work within my region when I was a regional administrator. And it was really, it occurred because we were having a stakeholder meeting with all the stakeholders in Region 2, and Center for States was present, and they asked the question, what has the department done to educate you regarding their safety model? And as the regional administrator, I had to sit in that meeting, and honestly, immediately, as soon as the question came out of her mouth, I knew the answer, and it was nothing. We'd never had a community training. We'd never really offered anybody the opportunity to learn. I mean, we had done our work with our judicial and all of that when we rolled it out, but we really had not done anything to bring our stakeholders along. And so through that experience, we developed our core trainings. And I'm happy to say that since that time, we've been able to hold 14 of those trainings throughout the state of Montana. And I'm sure Ike, when he talks today, could tell you how many people have attended those trainings. It's something that we're really excited about. We've had great turnout from especially our CASAs and some community providers within communities. And so we're super excited about that, because that does give us an opportunity to bring forth our safety model so that people understand the why behind we're making the decisions we're making. We're moving forward with transparency about that decision-making process. And finally, honestly, the reason that these core trainings are so important, it gives all of you as our system partners the opportunity to hold us accountable to that decision-making. It's important that you have that education and knowledge of our safety model so that you can do that. If we've gotten a safety decision wrong, we need our system to hold us accountable to correcting that. I mean, that's pretty simple. I'm just happy to say that we've been able to continue to hold those trainings. We've held 4 throughout COVID virtually, and I've participated in a couple of those. And I think we're starting to get into the swing of holding those. If after today, if any of you are interested or think your community would benefit from a condensed version of the core training, please reach out to us and let us know. We'd be more than willing to hold those. That being said, I'm going to talk about our safety model expert, and that is Ike Jessee. Ike is our training officer. He's worked in multiple roles, including a frontline staff to supervision within our agency. And Ike does a really nice job of bringing that understanding of our real practice to life in his trainings. I think that's a really valuable thing that Ike brings to his position, is he really truly does understand our work. And that hasn't only benefited our staff, but it's benefited all of our communities and the trainings that he's completed. I guess the last thing I'd like to say, I guess that's my introduction for Ike, is that I really hope that as we move forward and you all listen to Ike talk about our safety model, that you really are listening with the intent of trying to identify how you can use the information that Ike is presenting within your role, within our system, to help us improve. So with that, I guess, Justice, if you want to turn it over to Ike, that'd be great.
All right.
There you go.
All right, yeah. Absolutely no pressure. And I just noticed my tie is not straight, but absolutely no pressure there. But as Marty said, my name is Ike Jessee. I am the training development supervisor for Child and Family Services. Looking at some of the names on here, I feel like that kid that's getting called up for the minors, the big leagues for first day. So the nerves are a little bit there. But with that, I wanted to kind of preface where we're at in terms of how we're actually addressing pieces within our safety model in our communities in order to work with you all as partners, as Marty said, in order to allow us to better serve not only the families that we work with, but also you as our community partners. So when we speak of core training, when Marty approached me about it a few years ago and coming up with the community-based training, you know, it was the core. What's at our core? What are we going to actually address this as? And we were trying to come up with a way that we could explain this a little bit better in more simplified terms. And in the process, we determined, much like what Marty was talking about, that simplifying things doesn't make it easier. It actually makes it more confusing. So instead of simplifying things, we said, well, why don't we just share the information that we actually give to our staff? So what you're about to get in a literal crash course, I'm going to talk as fast as I possibly can to get you guys as much information as I can in this, is something that our staff or our new staff get over the course of about 96 hours. Now, this is drastically condensed down into the safety pieces, so I want to preface that, but this does work really well with questions. So if you do have questions, please let me know. I'll try to address those as much as possible, but I also want to get through this and provide you as much information as I can. So Marty talked about the start of our process in getting a report to centralized intake. So when somebody in our community or mandated reporter calls something in, we start out with that process of it being assigned out to the field for investigation or assessment. That is the first step in the process. But then once a worker receives that or is assigned that, at that point, then they have to turn around and they have to begin their actual assessment of that report or of those allegations of maltreatment in and of itself. And the first step in that process is the actual identification of immediate danger or lack thereof. So immediate danger in the assessment of it is the first point of the assessment process when there's direct involvement and engagement with the family. The CPS worker will go out and they'll assess for immediate danger throughout the life of the case and throughout the life of their initial assessment, primarily for an intake worker. But the first and most obvious time that immediate danger is identified is that during that first interaction with the family. So we get that report, we go out, we knock on the door, and more often than not, if immediate danger is identified, it's during that first interaction. Immediate danger is probably the most simplistic way of understanding pretty much what it is. A child who is in a state of danger due to a parent's act or omission or caregiver's act or omission, where there's a threat that or to the child for actual or substantial risk of harm. Now, I say that simplified. That's the statutory definitions and statutory language in there. So it does become somewhat of a gray area. And I know that Kelly had mentioned and Deb had mentioned those varying understandings of what safety is. But when immediate danger exists and when the CPS identifies immediate danger, that's our trigger that we have to do something, that we have to act. We can't leave that child in an unsafe situation. The response to that could be drastically different depending on circumstances. And we'll get into that as far as the intervention piece here in a little bit. In our CPS safety model, the Safety Assessment Management System, or SAMS, as we refer to it, we have specifically defined immediate dangers. So while there's no way for us to define every possible safety threat to a child, we have specifically defined immediate dangers that would categorize things. So if we're going to say it's domestic violence, we have a immediate danger that specifically says domestic violence is occurring. However, we don't have something that specifically says this is what we do if a parent exposes their child to methamphetamine versus alcohol use and impairment across the board. We talk about those things almost categorically. While the safety threat may be the parent exposing their child to methamphetamine use or being an impaired caregiver under the influence of alcohol, there's no way for us to specifically define our response or how to identify that specific to those substances. So we categorize those. Immediate dangers often lead to that immediate intervention or that removal that people are familiar with. But removal is not our only option, and we'll talk about those here in a little bit with the intervention as well. But when it comes to immediate danger, what I really try to impress upon folks is that with those clearly defined dangers and with those clearly defined steps to identify those dangers, it's very important to understand that at this point, CPS has to set aside their own beliefs, their values, their emotions, or opinions about whether or not they believe a child should remain in a home. This should not have anything to do with emotion. This should not have anything to do with opinion. This is specifically outlined in our model that states that through collaborative interaction with the family, we need to address the safety threat to a child and whether or not we can safely maintain the child in the home. This has to be the result as far as that collaboration with the family, even if the result of our intervention is the removal of the child from the home. We also understand that families are often frightened when we first knock on the door. When I've done these core trainings statewide, one of the first questions I talk about or that I ask the groups is, when you think of Child and Family Services and our role in your community, what do you view our role as? And almost exclusively in these trainings is we remove kids. When Marty and Nikki approached me about moving forward with these core trainings and going with this, believe me, I've been drinking the proverbial Kool-Aid on this as far as really pushing forward with the idea of changing that idea statewide, that we don't just remove kids, that we want to work with our families and we want to work with our community partners as well in order to address that. And in order to do that, moving forward with that immediate danger identification and the understanding of what is and what is an immediate danger is very important. So when we get to the point of we've identified a safety threat to a child, whether it's based on the actual allegations that were reported or just the observation of the CPS worker in interactions with the family, again, they're going to address this and be assessing for this throughout the life of the case. So not just the initial assessment. So this is not just for those areas that have intake and ongoing, to where the intake worker does the initial assessment and the ongoing worker would work with the family on the ongoing case. These are not just, subject to the assessment of an intake worker. We're looking for safety threats throughout the life of our case. We are really, really working with determining that at this point in our process, that the focus is on whether or not the child is in immediate danger. If the child's in immediate danger, then that means we have to act. So we can't leave that child in that situation without something to ensure the safety of the child. That does not mean that we can't, or that the child can't remain in the home. Assessing immediate danger is not a component of the safety model. It's basically a way of thinking. So it's not just a checklist, and that's what's really important to understand. So even though these are clearly defined, it's not like if A then B comes into play. It's very important that we get that in place, that these are based on firm criteria and not opinion or speculation. But it's not just going down a list and saying, does it exist, yes or no? We actually have to address this through that interaction with the family. So again, with that, the crux of this is, in order to accurately identify immediate danger within homes or involving children within the care of in the care of a caregiver, it's very important that our staff are able to accurately and consistently address these. But in order to do that, the basis of this is family engagement. And we've really over the last few years really put that in the forefront of engaging with families in order to gather as much information about their stories. So much of what we can, or our ability to collect information from families, is based on the quality of relationships that we build. The information that we gather is only as good as we are at being able to engage with that family, to have them feel the level of trust doesn't have to necessarily be there, but that they have to feel that they can actually communicate with us. We're not asking folks to like us. We're not asking for people to be our friends or to trust us necessarily. We build that rapport, and the trust comes, throughout the process as we go. So in order to gather this information, we have to be able to elicit conversation. And in that process, we need to be transparent. We have to be upfront with folks about what we're looking for and what our concerns are. We have to be able to explain the process. I personally, I take my car to a mechanic. I don't want them to just come and tell me that I owe them $3,000. I want to know why. I want to know why they're doing what they're doing, why they're telling me this. So we have to be able to explain that process when we're working with a family. We have to be able to answer their questions of what happens next and why are we doing what we're doing. We have to be genuine. There's no script in play here. Any one of you can go out and Google a list of child welfare questions for an investigation and find that there's laundry lists of websites that give all of these questions that you would ask to assess the safety of a child. But if what we've learned and what we know nationally is that, a list of questions or a checklist just does not, it doesn't cut the mustard. It just does not do what we need it to do in order to explain to families what we do. So believe me, and Marty was my RA, Marty and I have had these conversations, Nikki and I have had these conversations with her as my supervisor. My sense of humor doesn't come across sometimes. So with that being said, I have to be aware of that while still being myself. So if I go into a house and knock on a door and meet with a family that I know or that I've worked with before, if I'm not being the Ike that they know, or if I'm not being true to myself, it's going to come across as fake. And the families that we work with are pretty good at recognizing whether or not we're being genuine and authentic with them. So it's very important that we're upfront and we are who we are, because at the end of the day, we are people talking to people. And it's not about that whole CPS versus the family we're assessing. It's people talking to people. We also have to maintain that level of confidence. So we have to be confident in what we know. And that's where it's very important that we understand our definitions and our safety model, as well as going back to that piece of the explanation of the process. We have to be informative. We can't just walk into somebody's house and say, this is what I'm going to do, and deal with it, for lack of a better way to put it. We have to be able to provide them information. We have to give information to get information. So while the immediate dangers are clearly defined, it's not simply just due to finding something that fits and saying that it works. There's a specific set of criteria that must be met in order to state that a safety threat is an actual immediate danger. And in order to do that, it has to meet a threshold. And when we talk about thresholds, basically in the most simplified term that I provide to our staff, it's when something stops being one thing and starts being something else. So when we think of a threshold in our homes, when does it stop being inside and it start being outside? That's the simplest way to put it. And in terms of an immediate danger, when does it stop just being a concern, and when does it start being a threat to where we have to address something to ensure the safety of a child? And in order to do that, it must meet three clearly defined criteria. That threat must be immediate, it must be significant, and it must be clearly observable. So when we talk about these things, again, these definitions or the understanding and the belief of what is immediate, what's significant, and clearly observable could be different depending on who you're talking to. But for our staff, we clearly define these. And in order for someone or for one of our staff in working with their supervisors in identifying an immediate danger, we look at the definition of immediate, and we look at this as kind of, in order to meet this piece of the threshold, as whether or not, what our concern for the safety of the child is actually happening now, or it's likely to happen over the next several days. So when we look at likely to happen over the next several days, it could be that there's a safety threat when an individual is in the home. So say there's been violence occurring in the home, and say the individual that's responsible for perpetuating that violence is currently not in the home due to being incarcerated or maybe out of town for whatever reason. But when that person comes back, that safety threat returns. So it could be that person could come back within the next couple of days to, 3 to 4 days, 5 to 7 days. Other pieces could be that situation to where the weather turns cold and a family is not going to be able to meet those basic needs of their children to be able to provide protective shelter from the elements because they don't have resources to meet that. That could be that immediate piece too. So when we're articulating immediacy or imminence, it's very important that our staff remember concrete facts and evidence, not what we interpret, but what we know. So if our staff find themselves stating words like, well, it could, or it might happen, or it probably will, we're not at a point where we would more than likely be able to state imminence exists. And those are pieces that we have to address. So when we talk about immediate, just a brief example that I give to our staff as well is, if we're talking to a child at a school and they describe to our staff that they get in trouble every day, and that when they get in trouble, they get hit with a belt, which leaves red welts and marks on their back, sides, and stomach. If we don't have any other information based on what that child told us, we have to believe that child, based on the fact they get in trouble every day, and when they get in trouble, they get hit with a belt, that when that child goes home, that child's going to get in trouble and that child's going to get hit with a belt. So barring other information, that would address that immediacy piece. The second part to this is significance. And when we talk about significance, I simplify this for our staff and even for our community partners when we discuss this, is simply how do we tie this to the safety and the functioning of the child? So we have to look at the effects of the maltreatment or risk of the maltreatment. And maltreatment is clearly defined in statute as well. Are they severe based on the vulnerability of each child? So we know that each 5-year-old is not the exact same, that all 15-year-olds are not the same. So when we talk about vulnerability of children, we have to look at them specifically. So severity needs to be consistent with the definitions of abuse or neglect found within Montana Code Annotated. And we need to understand that then the definitions within for physical abuse, physical neglect, psychological abuse or neglect, or sexual abuse have to be met in order for us to state that maltreatment even exists. Then once we've identified that maltreatment does exist, we have to look at the effects of that and how it affects each individual child in that home based on their vulnerability. If the risk to the child is not substantial, significance doesn't exist. So we can't just say, oh, well, again, this could happen or this could cause a problem down the line. We have to look at this as meeting those substantial definitions and matching that actual or substantial risk of harm definition is outlined in Montana law. Clearly observable. With this one often becomes something difficult for our staff to comprehend because it can be a little bit vague. So when we talk about clearly observable, a lot of people think of observable as something that we see, when in fact, a lot of times we don't have visible marks on kids. We aren't present when domestic violence is occurring. We don't actually observe the maltreatment occur. But when we speak with families and we talk to folks, we look at clearly observable as the harm or threat of harm as being that transparent or understood to be occurring. It may be able to be seen, but we can also take that information based on what folks are telling us as what they've experienced and what they relate to be happening within their home. There is no guesswork in regards to clearly observable. So that proverbial rule of thumb is if we have to try to interpret what's going on, then it's likely not clearly observable. If we have to interpret what people are saying in order to meet this, then it probably doesn't meet this component of the threshold. There is no gut feeling. If something feels hinky, we can say hinky all we want, but we have to actually have evidence to support it. If everyone in the family is telling us that this is happening, then that's just as observable as if we actually walked up to the door and witnessed it ourselves. If mom, dad, the kids, or whatever, the breakdown of the family is within that home is stating that these things are occurring, that's just as observable as if we had a bruise or a mark on a child, as if everyone is telling us that this is happening. The threats, again, are specifically outlined and defined. And I don't know, I know our staff have seen these, and a lot of our, county attorneys and judicial partners have seen these. I'm not sure as far as with our public defenders that are on here. But within this folder, we call this our SAMS field guide. This has all of our definitions clearly outlined in here. So there's this little light yellow section that outlines our immediate danger threats. Just for time's sake, we don't have time to go through all of the definitions for immediate dangers, but they're categorized into 5 categories. One, the first category are threats that are related to the actual allegation of the maltreatment itself. So, things that are actually occurring and those threats that are tied directly to the maltreatment. Then there are threats that are identified that are specific to the child. So the effects on the child and how that safety threat or how that maltreatment actually affects the child. Then there are, the next category is the parent and how those threats or how those behaviors or actions are tied to the parent's behavior that may potentially put the child at risk of that immediate danger. The next category is the family as a whole. So what are the family conditions that may also be contributing to that safety threat for the child? And then there's that all-encompassing other, because we couldn't fit it in somewhere else, but there's only one threat in there, and that has to deal with services being unavailable or inaccessible. But what we're finding more and more, especially, that's one, I know that nobody is pleased with the COVID situation, and this hasn't been ideal, but that's one thing that we've really, really come to notice through this and has been beneficial on our part, is that services have become more and more accessible because the virtual platform has become more and more readily acceptable. So, I recently was talking to a worker who is seeing a therapist in Pittsburgh. Well, they live in a small community in rural Montana. Well, they may not have had a therapist available or a counselor or someone available to them to provide that service, but through the virtual platform that's now become more readily available, that safety threat has become less and less likely to occur. So in order for us to state that we have an immediate danger and actually identify that an immediate danger exists, we have to state we have a safety threat which meets the threshold, and then identify it based on one of these definitions as that categorical immediate danger threat. Marty touched on the immediate danger assessment earlier. So even when we didn't have the form, we were still assessing for immediate danger, and we're outlining it within our family functioning assessment, which, for lack of a better way to put it, is our written report. But in this, where the immediate danger assessment became very, very important is what Marty was describing. We understand immediate danger. We understand our terminology. The problem is not everybody speaks CPS. And that's the hard part that we have, is that we needed to be able to clearly explain to families why we were saying that their kids were unsafe. We needed to be able to explain this to our providers, to our attorneys, county attorneys, or assistant attorneys general. We need to be able to explain this to the attorneys representing our families and the kids in our cases, as well as being able to provide this in language that was easily understood without having a big background in our system. So when Marty and Nikki discussed bringing back the immediate danger assessment with our management team and our regional leadership, the idea of having the immediate danger assessment was simply to just bring it to a level that we could explain to anyone who doesn't necessarily understand our system why we were saying there was a safety issue, without having to look at someone and say, well, it's immediate, significant, and clearly observable. Because until roughly 9 years ago, when I started working for Child and Family Services, if someone would have looked at me and said it's immediate, significant, and clearly observable, the look on my face would have been quite a bit of confusion. So we knew that we needed to bring this assessment back in order to bring this to a level that we could clearly explain to families. So we need to make sure that when we are talking about these pieces, it's to a level that we are able to discuss with families exactly what it is in terms that they can understand. So our staff are trained to be able to, explain to a family exactly what that concern is in those terms. So if the concern is that the parent is using methamphetamine and is impaired while the sole caregiver or being the sole caretaker and provider to the child, and the child is 2 years old and needs that parent to meet their basic needs for, food, clothing, shelter, and basic supervision and managing the safety of that child, it could simply be, and I'm just using the name, Jane Doe admits to methamphetamine use while being the primary caregiver to the child and being impaired while the child is in her care with no other outside caregivers. It could be that could even be more complicated than it needs to be in order for the family to understand as well. But those are ways that we can explain to folks exactly why we're saying that their child is in immediate danger. Now, I know some of you are saying, I've seen these forms and it's not explained that way. With that, these are those pieces that Marty was talking about and referencing. If you're seeing these immediate danger assessments and they're quite wordy, or there's something that's confusing, please let us know. Because those are things that we need to get back into understanding, that even though we've talked about simplifying these, we still understand what we're talking about. So when any one of us picks it up, we can read that and we can understand it, but sometimes we still get a little bit wordy in those conversations. So please, if it's confusing, if you're representing a parent and it's confusing to you as their attorney, then we need to be able to explain that clearly. For our judicial partners, with our judges on the bench, if you can't clearly understand it, then please let us know so we're able to explain that. Because when we look at this as being educated members of our system and understanding these pieces of our system, if we don't understand it, then how can we ask the general public to understand things? Or folks who are in crisis, and the parents we work with who may be in crisis or stressed out, or maybe under the influence or suffering from some mental health issue, how can we expect them to understand it when we can't explain it to folks who are already familiar with our system? So please let us know if those things come up. Immediate danger assessments are supposed to be anytime we are intervening legally, meaning we're filing on something and we've identified an immediate danger. These are supposed to be accompanying our initial affidavits. So for those of you on here that are county attorneys or assistant attorneys general that are doing some of those initial filings in some of your cases, please, if you are not seeing these, hold us to that. Reach out and ask for these, because these need to be going not only with our initial filings to where the court is seeing these, but these also need to be then discovered out. Parents, attorneys, and parents need to be seeing these as well. So please let us know. This is something that's not secret in any way, shape, or form. So we need to be held accountable to that if we're not seeing those, or if you're not seeing those. So please let us know. Then we get to that intervention piece. Intervention can look drastically different when we identify an immediate danger. So it's very, very important to understand that anytime an immediate danger is identified and it meets that threshold of immediate, significant, and clearly observable, we have to act. No matter what happens moving forward, we have to, in our safety system, have to have a protection plan in place. A protection plan is a short-term, basically, plan that we work with the family in order to be able to maintain the safety of the child while we continue our assessment. So there's a couple of ways that these can happen. We work with the family agrees to this, and if we can at all manage the safety of the child while the child remains in the home, we put in place an in-home protection plan. Under our model, the in-home protection plan can be in place for up to 60 days. That is in line with our statutory obligation to complete our assessment within a 60-day time frame and have that assessment closed. If for some reason we cannot maintain the child in the home due to safety concerns within the home or lack of available safety resources to assist in managing the safety of the child in the home, at that point we would have an out-of-home protection plan. An out-of-home plan can be in place for up to 30 days, which falls in line with all of our requirements in regards to maintaining children and not keeping them out of the home statutorily for longer than 30 days without a court order. A protection plan is voluntary. So when I say it's voluntary, parents have the right to agree to this. But if they do not agree, we still have to maintain the safety of the child. We've identified a safety threat that says we have to act. So at that point, if a parent does not agree or cannot agree to that protection plan, or we're unable to identify a protection plan that would be able to manage the safety of the child voluntarily with that family, at that point we would have to provide, the worker would have to provide notification to parent. So that basically notifies the parent that of our concerns and starts our legal process for legal intervention. Once notification is provided, that notification form, right? I mean, and I make this joke all the time, right? We're the government, we have a form for that, don't we? I mean, we have forms for everything. So when it comes down to a form, the form outlines their rights. So it clearly outlines the rights of the parent and the legal process moving forward. So it discusses their right to have a hearing. So it outlines the show cause hearing. It outlines the legal process of what's happening and their right, you know, to consult an attorney and have all of that information provided to them. By having this in a form, it's supposed to solve pieces of that confusion. So it's very, very important that the family then has that to reference so if they have any questions moving forward. Once notification is provided, our staff have to provide within 2 business days an initial affidavit to the attorney that will represent us in that initial filing. So either the county attorney's office or the assistant attorney general, depending on that case and how that will be handled at that time. Then the county attorney's office would then, you know, formulate and develop their petition. Those things would be filed. And then this is you know, with legal partners in here, I don't have to have a whole lot of explanation into the legal system as far as emergency protective services, temporary investigative authority, or temporary legal custody. But at that point, that would be our legal intervention pieces to where we would actually be seeking relief from the court in a court order. So just a little bit deeper into protection plans and what those actually look like. So what protection plans actually have to accomplish and what they must do. They have to be immediate. So if we've identified an immediate danger, a protection plan must be in place prior to the CPS worker leaving the child in that home, be it whether it's in the home with safety resources or, you know, in an out-of-home placement and an out-of-home protection plan. That plan has to be in place prior to the worker actually leaving the home. These are short-term again, and I know that when we talk about this, 60 days for an in-home or 30 days for an out-of-home doesn't seem like short-term, but in the life of a child, you know, 30 days in order to ensure their safety, what we assess is vitally important in order for us to make sure that we have the amount of time to be able to, you know, thoroughly assess, analyze, and analyze the information we have and complete our process in order to ensure that the safety of children is properly identified and addressed. With this, it's also very, very important to understand that even though a child, we have up to 30 days, these are priorities on caseloads and report loads. So when somebody has a protection plan in place, it's vitally important that they are working this and this isn't just sitting on the back burner. Because when kids are out of home, we need to make sure that we're doing our level best to ensure that if children can be returned to the home, that we do so as soon as possible. So protection plans have to be sufficient to control for the safety threat. So we don't just put in a plan that says, oh, well, I'll make sure that this doesn't happen and leave the parent in charge of the safety. It has to actually manage and control for that danger. So we have to clearly identify what the immediate danger to the child is. Simply, what is in this is a form that has a box that says identify the immediate danger. Our staff are trained to take what's on the immediate danger assessment and put it directly into this box so that there's no confusion. The family gets to see the protection plan as well. They are engaged in and have a part in developing this plan as well. But as part of development of the plan, as the CPS worker in the field, they have to confirm that the plan actually manages for that threat. So there's a description of how it will actually work to address the safety threat for the family, as well as any people that will be responsible for the protection plan. So if it's going to be grandmas, grandpas, aunts, uncles, the neighbor, who's going to assist us in helping manage for the safety while we're completing our assessment? Because if the parents were able to manage for the safety of the children, then we wouldn't have identified it as an immediate danger threat in the first place. Parents have to be willing to cooperate with the plan. If they're not willing to cooperate with it, then we just talked about that other intervention, but then it's not a voluntary piece. At that point, notification would have to be provided. If children are going to be placed outside of the home, CPS also has to do an evaluation of the home where the child's going to be. So if we're going to have the child over at grandma's house, say, at that point, we'd have to go to grandma's house and ensure that the safety of the child can be managed within that home, and not just, taking a child from one situation where there's a safety threat and potentially putting them into a home where there may be another safety threat. And then those timeframes for the protection plan and the oversight. So families have a right to know how long this will be in place. So it'll either say for 60 days or 30 days, and how often this will be revisited. Our staff and our supervisors are staffing regularly. So protection plans become a priority for staffing. Are we moving to a level to where we may be able to alleviate that safety threat, or have we identified that the safety threat's no longer a concern and children can go home? So at that point, will it be staffed weekly? Will it be staffed every 3 days? Oftentimes, and when I was a supervisor, these protection plans become almost the subject of every conversation you have with a staff member, anytime that report comes up. So these are staffed regularly in order to address those safety concerns and whether or not they're still present. And then the family needs to know that as well. When it comes to protection plans, the Indian Child Welfare Act comes into play extensively. Because under the Indian Child Welfare Act, anytime a child is placed outside of the home of the parent, or we're inhibiting their right to parent, at that point, we would be asking for court oversight at that point. So not necessarily that we would always be filing. There are courts, and I know those of you that work within judicial districts that have this in place, there are courts where we can get in front of the judge and have the judge sign the protection plan. There's actually a line on the back of the protection plan where the judge would sign off on it. The parents would agree, and the judge would state, yes, there's that court oversight at that point. But if we don't have the ability to do that, like in some of our rural districts where the judge may not even be in the same county or even available at that point, oftentimes where a Native family is willing to agree voluntarily to, follow through with the protection plan, these may be where you see an affidavit for emergency protective services and temporary investigative authority. Just basically so we have that court oversight. And this is not in any way, shape, or form to single out Native families. This is basically to hold our feet to the fire and hold us accountable to make sure that we're following all the provisions of the Indian Child Welfare Act at that point. Are there any questions about protection plans or immediate danger before I move forward? I know there's been some things popping up, I'm assuming, in the chat box, but I wasn't completely sure on some of those. So,
hey Ike, I just wanted to also give you an update that we have about 15 minutes left for the rest of this. I want to make sure you're able to get through that too.
I'm flying now.
Okay.
All right, thanks. So the next step in our process is the actual identification of the impending danger. So impending dangers address specifically that underlying causation. So what is the cause that actually may have resulted in an incident that we got a report on? These are those deeper, underlying pieces that maybe haven't quite come to the surface yet, but they're contributing to the safety threats or safety concerns of the child in the home. When an impending danger is identified, there's also a threshold that must be met. And in order for us to say that an impending danger is met, we actually have an even more stringent threshold. So there's 5 components of this. And within this, we have to have an out of control behavior or condition within that home, which resulted in that safety threat to the child, and it's not being managed internal to that family system. Severity, so that's that significance piece, very similar to significance for immediate danger. Imminence, very similar to immediate. observable. So it has to be something that we can clearly articulate, that we know how this is happening. And then we have to tie it specifically to the vulnerability of the child or children that it actually applies to. Very important to be utilizing these as clearly defined also within our field guide, in order to understand that not only are these what we will be moving forward with our safety planning, but also these are those conditions that we would look at as far as those underlying causes and the contributing factors when we're developing treatment plans as well. So some of these pieces are very important. So if we haven't accurately identified what the underlying true root cause is at that point, we may be, moving down a tangent or down a trail and pick the wrong path, which we could be incorrectly, addressing what the concern is, not only in managing for the safety of the child, but also addressing those behaviors or those conditions which resulted in that safety threat to the child. So the safety management and actually addressing the safety concerns of an impending danger. Safety plans and protection plans address two different things. Protection plans actually address the immediate danger, while a safety plan addresses the impending dangers. So when impending dangers are identified, we have to put something in place that manages for that impending danger threat as long as that threat is present. So that being said, safety plans do not have timelines. So there's no 30 or 60. So if you're working with a family on an ongoing case, there will be a safety plan in place. There should be one readily accessible. It should be something that the family knows about, knows exactly what the plan is, as well as safety resources. So as long as those threats are present, then we have a safety plan. At the time that an immediate danger is identified and a supervisor approves that immediate danger as being accurate and correct, within 24 hours of that occurring, a safety plan determination has to be completed by the worker. More often than not, when they're staffing this with their supervisors, those conversations come up and it's addressed directly as, here's my concern and here's where we're going to walk through the safety plan determination to determine whether or not a safety plan, could be in home or out of home. A safety plan, much like a protection plan, has to have an immediate effect. So if we're going to put a safety plan in place to address an impending danger, it can't be in place, but the safety resources aren't available. So it has to be immediate. It has to must only contain safety services and actions. So under a safety plan, no treatment services should be included in these. Safety plans are not contingent on treatment services. A parent, in order to have their child placed in their home, does not need to be engaged in chemical dependency treatment. We just need to be able to manage for the safety of the child while they're in the home. We cannot make promissory commitments. So we can't say that, oh, well, we can't have, say, mom say that dad won't be home unless grandma can be there. We have to have a way to verify that. So it can't be, I'll keep so-and-so out of the home as long as my kids can be in the home. We just can't make promises on that. Safety plans are reviewed at a minimum of every 30 days, but as you're talking to regional administrators in your breakout groups or supervisors or even CPS workers in some of these, what I can tell you is these are staffed way more frequently than every 30 days. When determining which safety plan to use, there's a couple of types of safety plans that we can utilize and, what we're actually addressing as far as, do we use an in-home? Do we use an out-of-home? And there's 4 specific questions that have to be asked in order to address that. And the first question that needs to be asked is there a home-like setting where the parents and children live? So home-like, you'll notice it does not say, do they have a home? It doesn't have to have, a ranch-style 3-2, with a white picket fence. It's just, is there a home-like setting? And the way we train that to our staff is, where would you find the family if you needed to locate them tomorrow? Where would they be? And is it consistent enough to where the needs of the children can be met in regards to their safety? The second question is there at least one parent that's willing to participate in that plan? So sometimes we have one parent that's willing and one that's not. We have to address that accordingly. The third question that comes in is, are there safety resources and activities available and accessible that would allow, the safety plan to be implemented. The last question is the home calm enough to be able to implement an in-home safety plan. So the workers walk through those specific to the criteria and the conditions within the home with their supervisor and discuss those and have that question about how do we have, how do we adjust whether or not yes or no we can answer these 4 questions. If at any point we answer yes to the question that yes, we have yeses to all 4 questions, then we must use an in-home safety plan where the children and their safety are maintained in the home. If we answer no to any of those 4 questions, then at that point, an out-of-home safety plan must be used because we've determined we can't maintain the safety of the child while they're in the home. There's also times where you would use combination in homes, out of homes, to where potentially a parent, we may have that out-of-home situation when a safety resource isn't available, and that may be when a child, say, goes to daycare and isn't in the home with the parent when a safety resource isn't available. Which plan to use comes down with those safety plan determination questions that we just talked about. What's included in a sufficient plan? So very similar to the immediate danger conversation in a protection plan, all of the safety plans have to identify what the danger is, those conditions which resulted in whether it's an in-home or an out-of-home, the actions and services and providers that are responsible for those, how those providers are managing for those threats, the agreement of the caregiver to follow along with the safety plan itself. They don't always have to agree with everything, meaning they don't have to agree with the threat specifically. They just have to be willing to follow along with the safety plan. And then that oversight. So how are we going to oversee it? How are we as an agency, as Child and Family Services, going to interact with that family and those providers to ensure that the safety of the children is being maintained while they're in the home or even out of the home in a placement. Once we've determined that children have to be placed outside of the home due to one of those safety plan determination questions being answered as no, we have to also determine what would need to be in place for those children to be able to be maintained in an in-home safety plan. Parents do not need to be able to maintain the safety of their children on their own without assistance. They could have grandma or aunts, uncles, a neighbor, a family friend move into the home or be able to assist in managing for the safety of the children in some way, shape, or form, which would allow us to mitigate the concern that we have, which resulted in us not being able to have an in-home safety plan. Again, this is not tied and should not be tied to a treatment service. A parent does not have to complete their treatment plan for a child to go home. And in fact, a child should be in the home while a parent is still working their treatment plan. But we'll talk about that a little bit as we go too. But what are conditions for return? Conditions for return, very, very simplified. If we say no to a safety plan determination question, condition for return is what conditions have to exist for that no to be a yes. That's all it is. They're part of the case planning process, and they need to involve the family. So while this slide states that it needs to be developed within 5 working days of the safety plan determination, sometimes that's not possible if we need to be able to involve the family. We don't want to leave a child in an out-of-home safety plan or an out-of-home placement simply waiting for a meeting to occur. So sometimes it's just the logistical pieces, and sometimes that 5 days goes a little bit longer, but we would much rather work outside of that 5 days and ensure that we can, keep a child in the home or maintain the child in the home under an in-home safety plan than have to place the child out of the home only to 3 or 4 days later bring the child back home. We know that that's less traumatic for the kids. So conditions for return, the parent doesn't have to change their behavior necessarily. We just have to be able to mitigate and manage for that safety threat while the child is in the home and while the children and the parents continue to work on those safety issues with their kids there. So moving from an out-of-home to an in-home, basically what does the family need to be able to maintain the safety of the child? So when we're talking to our CPS staff, it's about what safety services have to be in place, how quickly and reliably can they be implemented? So if grandma's on her 3-week bus tour of Branson, and that's who's going to be in the home assisting with the family and grandma's not available, well, then we can't reliably and quickly implement that. We'd have to wait till grandma's home. And then, as Justice Gustafson indicated earlier, it's challenging that compliance to things. It's not, are they complying with their treatment plan? Are they even working their treatment plan? It's, can we maintain the safety of the child in the home with the family? So then managing the safety threats after the child has gone home for, after reunification. At that point, the child's safety is continually managed and monitored by the CPS. So whether the CPS is in the home 2 to 3 times a week or 1 or 2 times a week, and then having contact with those safety resources and safety providers who are interacting with the family more frequently. The caregivers at that point should still be working on their treatment plans. So oftentimes we're finding that reunifying a child when we can maintain the safety of those children in the home often is an incentive for a parent to work their treatment plan even harder for, and I know it sounds somewhat facetious, but literally to get us out of their lives. So with that, it's very, very important that we continue to manage for the safety of the child while still facilitating their parents' work on their treatment plan as they move forward. So that is probably, and honestly, Kelly, I think that's a record for me. That's probably the quickest breakdown that you're ever going to get in regards to safety assessment and the management of safety. And I hope that I didn't confuse things further. I'm noticing several things popping up in questions. And if anybody does have questions now, I'd love to answer them to the best of my ability, or even I can refer those over to Marty or anybody else that could answer those.
We have just a couple minutes for questions, then we're going to take a break. So anyone have a burning question?
I have one if no one else has one.
Sure, Kelly, tell us what it is.
Okay, I'm looking at the SAMS. You said it's a way of thinking. It's not A, then B. Mm-hmm. And you need to address it by interaction with the family. So often parents, when CFS and or police show up at their door or there's a situation, they are going to be uncooperative, or hysterical, angry, all of the above. And we often hear that CFS then had to move because they were uncooperative or they were not able to have a conversation with them. When I don't, so 2 questions. Okay. It seems like you're removing just because they're uncooperative or upset, and not because there's this objective other evidence to show that they're in immediate danger. They say, well, nothing we could have done because they were uncooperative. Well, there seems like there should have to be more. And then even if it's found that there was other evidence and at that moment in time, whether because they were uncooperative or upset, then once they calm down and are cooperative, or I forgot to add the situation of they're taken to jail, but then all charges are dropped, they're out in 2 days. So now we do have a cooperative, not upset, available parent, then the kids aren't returned at that time. So whereas maybe they weren't willing to do a UA for CFS always says, if you just did a UA and showed me you're clean, you'd have your kids. But at that moment in time, the parent wasn't able to cooperate or whatever. But then when they are, and they're willing to give a UA and they've already done their CD val and it's only a few days later, then the CFS will say, well, we need a month or 6 weeks of clean UAs before the kids can go home. So I'm not understanding that uncooperative, upset in time and how that's analyzed by CFS.
Yeah, the situations that you're describing, I would say you're right. When law enforcement, the fire department, or family services shows up at your door, you're not having a great day and you're going to be a little stressed. People are going to be, uncooperative. People are going to be, resistant. At that point, you are correct. Our staff need to be engaging with that family. Simply being uncooperative does not make your kids unsafe. Much like the statement that you made about, well, if a parent UA'd, just being in a cup doesn't make your kids safe or unsafe. It's the circumstances that resulted in the behavior that created a safety concern. So that's what when I was saying, you know, it's a way of thinking. It's not just check a box that they UA'd and it's a plus or minus. It's more about what are the behaviors and the conditions within that home which are resulting in a safety concern for the child. So the other example that you gave about a parent going to jail, if the concern is that the parent is not able to parent the child because they're incarcerated, and that's our safety concern, is there isn't a safe and able caregiver. At that point, when they are able and they're there, then yes, we should be working to return those children back into that home. The cooperation piece is where oftentimes it does get hung up. Is that piece of that misunderstanding, and we are working with our staff diligently to understanding that it's not just about whether or not they do what we ask them to do. It's whether or not we are working with them to maintain the safety of their kids, not just checking a box that they complied with a request.
Thank you.
Yes,
so we can probably go on for quite a while, because I imagine many of you have had experiences maybe like similar to Kelly's that you'd like to talk about individual. We are at kind of our time. We'd like to take a 5-minute break here, go get some more coffee, restroom, whatever, and come back. We're going to talk about hearings.
Thank you very much. I appreciate your time.